and gentlemen, and a very warm welcome to the Indian Law Institute. Please join me in welcoming our chief guest for the evening, Honorable Justice Mr. Kumar, member NHRC. I will request our guests and Professor Sinha to please begin today's program with the lighting of the lamp, please. I now request Professor Dr. Manoj Kumar Sinha to please welcome our guest with the bouquet of flowers. A very warm welcome from all of us, sir. Please allow me to invite Professor Dr. Manoj Kumar Sinha, Director, Indian Law Institute, to please give a welcome address.
Thank you very much, Richa. Honorable Chief Justice Mahesh Kumar sir, Member National Human Rights Commission of India, Professor Dr. Anurag, Professor Indian Law Institute, Sri Srinivas Chandrapurski, Registrar Indian Law Institute, and all the participants, students, and also Professor Vatti is here. So, Madam, welcome for this particular program. Lordship, this is your first visit to this, particularly for the function of the Indian Law Institute. But we have a very long relationship with the National Human Rights Commission of India. And for the last 7-8 years, we have been conducting a series of activities, training programs for the police officers, probation officers, judicial officers, and others like 6-7 for NGOs, like this program every year we have been doing. But last 2 years, because of the pandemic, we were not in a position to conduct the virtual program, so we decided this year again. Now we are reviving, and this is our third physical program. So, and that is the reason we request very limited number of students to come here to maintain a standard operating procedure, also a COVID protocol. So not everybody is invited for this particular program, but we are very happy that we have started physical program in the Indian Law Institute, and for some of our students and some of our colleagues or senior members of the bar, they also attend the university program. We are very happy and pleased that you have accepted our request over the phone, and that's this we followed subsequently at the moment I spoke to you, and we feel very honored and privileged that you gave your consent over the phone, and then you accepted our request to release this particular book. About the book, I think Professor Anurag will speak some in detail about the book, which has been appreciated by the Attorney General. He personally wrote a letter to me acknowledging the book is very good, and he mentioned that he will use this book in his currently the matter which is going on, and then others also appreciated the book on this. So it took almost 2 to 3 years to complete this particular book. An extensive work has been done by the Professor Anurag, and little bit I have supervised, but it goes to the Anurag. What is important, the subject, if we go a little bit on the content of this law of sedition in India and freedom of expression, why it is so important, and I see in a different perspective, even in the constitutional perspective, if you see, though we study the constitution in an independent manner, when we read part 3, we see it independently, but when you try to read the part 3 with the emergency provisions, and then Part 3 has also its limitations. But if you read the Part 3 and emergency provisions started particularly Article 352, then you see emergency state preservation is become very important. Even extraordinary situation when the existence of the state is in a question, then state priority is given to the state. So like balancing of the individual rights and state becomes a crucial question for each state. And this is not only in the domestic law, it also under the international law. So when we discuss and talk about the human rights, so we have a fundamental rights, and you read along with the emergency provision, you say that which actually state is supreme in some manner when extraordinary situation, war, external aggression, or any other situation which demands some kind of extraordinary stay by the state. Of course, that is not open-ended. That has to be a limited period. And like we have witnessed, Lordship, we had 3 occasions. Article 352 national emergency was imposed starting from the 1962, which continued till 1968, and then we have also in 1971, which continued for the along with the 75. But first time internal disturbance become in 1975 national emergency. So we had 3 occasions of the national emergency was imposed, and we see how fundamental rights and state preservation become so important. And even court, when court had an opportunity to discuss, not only in the ADM Jabalpur versus Siddhant Shukla case, when we talk about the emergency provisions, we look into the ADM Jabalpur, but it was also discussed earlier in 1964 in the Mohan Chaudhary versus Chief Commissioner case in the 1964, which court has also declined. What court has observed in 1976, that was also, that question was about the validity of Defence of India Act 1968. So we see, we go back, but when we did discuss about the emergency, we go to the ADM Jabalpur, but there are number of cases, and subsequently we have series of cases during 64, 65 and 66 related with emergency preservation. So this is we have in the domestic level, and when we look into the international level, so human rights is very fundamental. But all human rights instruments, even the whether it's a European system, whether it's American system, or whether it's an international universal system, has given a special space to the state to deal in with extraordinary situations, some way to balancing. And it allows the state, even the European, which we consider you have been to the Europe, you studied there, and European people feel, very early legal binding instrument, European Convention on Human Rights has come in 1951 and finally entered into force in 53. So much before other international human rights instruments. But Article 15, paragraph 2 of the European Convention on Human Rights, which allows a state to suspend the enforcement of fundamental rights in time of extraordinary situation or emergency on the for the limited period. So we see that, and then, however, what they have done in the human rights instrument, they have also recognized that certain rights cannot be suspended even in time of emergency. So they categorize, they derogate. You can derogate, but you cannot derogate. So certain rights are so fundamental or inalienable that requires to be respected in all situations, like right to life, prohibition against torture, prohibition against slavery, non-retroactive application of law. These are the 4 common in almost. So right to life becomes very important, which was achieved in the Indian scenario little bit later after the 44th constitutional amendment. The 2 rights which more or less acquired the similar status, what we can call as an inalienable right, like Article 20 and 21 of the Constitution. We have many things to discuss, but I see that particularly grave and imminent peril, or like the situation that emergency can be imposed, rights can be suspended. So whether sedition law attacks on the infringement of freedom of expression, whether it has to be balanced. So these are the lot of questions which has bothered scholars time to time, and I'm happy it's not a new exercise, though it's an independent exercise, but we have in the Indian Law Institute in 1964 a book which was done by the Dr. Gopal Krishna sir, he prepared a book that was for Law of Sedition in India as a part of fundamental rights in 1964. So we have a book already there, but this book is independent. It's not so Anurag, we have not revised that book. It's a totally independent from the first book, which was long time ago. So the subject was equally concerned even in 1964 sedition, and we are discussing that particular time that the Kedarnath has come, and then like it's become very important. So a lot of issues are there which I think will my colleague Professor Anurag will take up and discuss and enlighten all of us on that particular. And of course, we all are desperately hearing your personal experience and your like support to share with like all of us and the importance of this particular like freedom of expression, and also whether Sedition law is like relevant or irrelevant, whatever the idea you have on to discuss. To end my welcome address once again, before I formally end, I say that we are very happy that all of you accepted our request, and we look forward for your guidance and support, not only the activities of Indian Law Institute. We will be very happy, we will be happy to associate ourselves more actively with the National Human Rights Commission and the your like leadership along with the Honorable Chairperson Justice Honorable Arun, who was also very much involved in Indian Law Institute. With this, I once again welcome you, Madam, I welcome you, and all of you for this particular program. Thank you very much.
Before we introduce the book, I would request our guests and Professor Sinha and Professor Anurag to please release the book. Now invite Professor Dr. Anurag, the Indian Law Institute, to please introduce the book and address our gathering.
Honorable Justice Mittal, Member NHRC, respected Director Professor Manoj Sinha, sir, who is a driving force for our colleagues, Registrar sir, Madam Santosh, learned legal fraternity, present here physically, learned friends present online, law teachers, judicial officers, police officers, they are present online also. I like colleagues, without whose support, neither the publication was possible, nor these type of programs are possible. Research scholars while I and outside, my advocate friends, and all those who have joined us offline and online on such a short notice. The task assigned to me is to introduce this book. But I will take some liberty to discharge a far more primary obligation, and that is to convey my deep acknowledgements to all those who were part and parcel of this book. I will tell them, friend, philosophers, and guides, this work has reviewed 3 levels of scrutiny. Senior academicians who have reviewed the book thoroughly. Senior academicians who have reviewed 1 chapter. And research scholars and some academic friends who have reviewed the work individually. Fortunately, one of the greatest of the great reviewers is present in this house. Before I reveal the name, let me tell you that there are 3 types of persons. One who only think about themselves. मेरा ग्रोथ कैसे होगा, मैं कैसे आगे बढ़ूंगा. they are within their right to think like that. Second, there are people like me who think about their growth and think about the potential growth of others also. But there are third category of persons. They think about the potential growth of others even at the cost of their own growth. And one of the reviewer is Professor S. N. Sinha. Please have a great hand for him. He is present here. He sat here with us. For all ILI affairs, he is always present. But for this book, he sat with me in my room for maybe late hours. यहाँ कॉमा क्यों लगाया है? यहाँ फुल स्टॉप क्यों होगा? ये citation क्यों missing है? Such minute things. Sometimes that seems irritating also to you. But when the product comes, then you understand how those minute things were of great significance. Because they give you utmost satisfaction. I'm really grateful to Professor S. N. Sinha, who has thoroughly read the book and because of whom various changes I had to make. I am deeply grateful to another professor, Professor Sushil Kumar Verma of Banaras Hindu University, under whom I learned the art of doing research work. We lost him 3-4 months back. Professor Sushil Kumar Verma was retired from BHU. Incidentally, both served ILI. Professor S. N. Sinha was also in ILI and Professor Sushil Kumar Verma was also in ILI. So you can understand, and both were devoted to research. So we have inherited two great scholars in the area of research. On the second level of research work, review work, I wish to acknowledge Professor A.K. Awasthi sir, Lucknow University, Professor A. Subramaniam, Senior Fellow, ICSSR, Dr. Rajendra Pandey, Jamia Haddad, now in Meerut University, Dr. P. Puneet, formerly with ILI, now Associate Professor, Jawaharlal Nehru University. Dr. P. Puneet has reviewed the largest chapter, that is on analysis of section 124A. And because of his review and his compelling questions, I had to drop at least 10 to 12 pages. Dr. Deepa Kasra, who was with ILI and now in JNU, SIS Center. My learned colleague, Latika Vasisht, they have read and reviewed 1 or 2 chapters and provided insightful comments. The third level of review was mainly done by the research scholars, mainly in ILI and outside. I would acknowledge the contribution of Setu Gupta, who is currently a PhD scholar. That time he was a consultant in Law Commission. Anandita, who has produced a dissertation work in ILI, in LLM, was a PhD scholar. PhD was just awarded on free speech. Anandita. Shivam, he's a PhD scholar currently in Delhi University, a product of ILI, LLM, a product of Chanakya also. Piyush Kumar, a product of ILI, LLM, assistant professor in Delhi University. Amit Raj Agrawal, a gold medalist from ILI, a known face for his critique. Nivita Chaudhary, who is a PhD scholar and editor of ILI Law Review, chief student editor of ILI Law Review. Bhavna Mehrotra, she is a PhD scholar in Allahabad University, a product of ILI. Vishal Sharma, a product of ILI, now assistant professor in UP-ES. So these are the persons who have reviewed 1 chapter or 2 chapters. A chapter has been given to 2-3 persons in order to get all types of insights. And please believe me, I had to change a lot because of these all comments. Mallika Ramchandran, who has done her PhD from here, is extremely good in editing, excellent in editing. She is currently working with Oxford and in many other publications. I acknowledge Amit Vasisht. He was a PhD scholar in ILI, currently a PhD scholar in Western University, Delhi. He's a PF commissioner also. Indeed, he has helped me framing some of the ideas. We disagreed, we agreed on many points. My research scholar Prof, Jia Ansari, they helped me a lot. Two research scholars of mine, Charvi, Kumar and Mani Govind. Charvi is here, I think. Charvi has devoted a lot. I would request everyone to clap for Charvi because of whom she was a great helping hand for me in this work. When the book was under process, as I teach here national security laws, that was an additional advantage to me. So, LLM students have also contributed to this. I will record R.K. Venkatramani, Sravan Suhas, Deepak Parashar. Let me tell you a small thing which probably anyone can mistake. We always know that Supreme Court benches are in odd numbers 5, 7. So when I was reading Ramesh Thapar and Rajbhushan, so I've heard many times it's a constitutional bench judgment. So I have in the footnote we have written that it was a 5 judges. I did not see whether it was really a 5 judges or not. And it was almost on publication when Deepak indicated that it was not a 5 judge but 6 judge. And the ratio was 5:1, not 4:1. So I told her, no, this mistake cannot be done. But then I went to verify, I found that yes. And then there were initial days, 6 judges were also there, 4 judges were also there. So that was a blunder, that was a mistake, that was averted because of Deepak. Then Dhanendra Patel, Amit Kumar, Jasleen Kaur, Varun Yadav, Ritesh Mehra, who is currently a PhD scholar with us. They were LLM elective national security law students. Others who worth mention are Kasar, Priya Das, Pankaj Chaudhary, Pooja Kodra, Juhi Singh, and special acknowledgement to Ravi Kumar, who is a judicial officer. I'd also acknowledge intern with me those days LLB students, Abhishek Anand, Ashu, Priyanshu, Arth, Singhal. These were the 3 levels of review. Now, ILI is an institute, so because of its institutional significance, people keep on coming. And that was an added advantage to us. Professor A.K. Kaul, who is no more with us, he was a regular visitor of ILI library. So I used to discuss with him a lot on various issues. Professor B.C. Nirmal, both were Vice Chancellor, former Vice Chancellor. Shri Vinay Singh ji, who is present here, Deputy Director of ISIL, he kept on asking me, what is happening to your book? What are you doing? Why not this? He is present. I would request everyone to clap for Vinay Singh ji. Dr. Manoj Pandey, who is a guest faculty in ILI, an advocate. Dr. Lokendra Malik ji, who is a voracious reader, writer, an author of around 20 books. Avdesh Dubey, among various good friends, Avdesh Dubey has given excellent insight for us. Manindra Dubey, they visited ILI, and whenever anyone visited, we discussed with them. Once this review process was over, we thought that let us present this book before publication to certain universities. So this book, before publication, we presented the findings of this book in National Law Institute, Delhi, in JNU. Faculty members of Maharshi College of Law, Noida, University of Petroleum and Energy Studies, Dehradun. We have presented this book to these places. Non-teaching staff needs acknowledgement, all acknowledgement, but I would especially thank Sonam, Gunjan, Sanjeev, Rohit, and especially we all love someone, Govindji. I acknowledge Bhupendraji, Bujinder, Rakesh, our registrar, Christy sir, Dr. Verma ji, Neena Bhatia ji, and Rashi Khurana. There were many others who helped us very much, but then these were special contributions. Now, to introduce this book, when we started doing, as it always happened that we have certain confusion, certain wrong confirmation because of news items available. For example, I often heard that there is no conviction from the Supreme Court on sedition law. And I have gone with that. And such this type of reports, you won't believe these type of reports have been published in like Law and then big magazines like Hindu. I have discussed this in the class. Let's see how these news are sometimes misleading. Because Kedarnath Singh case was a conviction case. He was imprisonment. He was imprisoned. Kedarnath Singh was convicted by High Court, by the trial court, by High Court, by the Supreme Court. But then there is a dominant narrative, and therefore we go with the narrative. So in the beginning, so this book here has 6 chapters. In the beginning, we have raised 21 questions. 21 questions. And I will take 2-3 minutes to discuss with you what are these questions, only questions. Is this law against democratic values? Is the provision of sedition under IPC itself seriously flawed? Or is its operation by authorities problematic, or is it both? Should the Parliament repeal or amend Section 124A? Why does provision of Section 124A does not use mens rea element? Is it a general intent crime or specific intent crime? Is it a conduct crime or a consequence crime or both? Why did not the Constitutional Bench in 1962 in Kedarnath Singh declare this law unconstitutional? What is the meaning of conviction of accused Kedarnath Singh in this case? Is the interpretation of Supreme Court progressive in nature? Is the interpretation seeking proof of incitement of violence or tendency to create disorder justified? Is actual violence or disorder a necessary element? Should it be decisive at conviction stage or at punishment stage? Is the interpretation given in the 20th century, in 1962 case, is still relevant in 21st century, or is a reformulation warranted? And you will recall that despite a Supreme Court Constitutional Bench pronouncement in Kedarnath Singh, Supreme Court has again accepted the constitutional validity of Section 124A. What is the impact of Naxalite movement, terrorists, disintegrating forces, which are traumatic threat to the survival of social order? And I had the honor to interact with Honorable Justice Mittal sir, and he was also raising these issues. Is the influence of technological revolution and social media a relevant consideration for examining issues involved in Section 124A? We have come from Stone Age to Space Age, Space Age to Cyber Age. Is it really relevant? What types of slogans are to be avoided? Which are to be admonished? And which type of sloganeering ought to be punished under sedition law? Should secessionist utterances be addressed through sedition law? And we all know that there is a case of Bayan Singh, and Bayan Singh case has been presented as if it has legitimized anti-India slogan, which is a complete misreading of the issue of Bayan Singh case. Is time right for judiciary to relook into prevailing sedition law and re-examine its constitutional validity? And we never thought that when we raised the question, the Supreme Court will really take this note of that. Yes, the time seems to be right. That let us discuss first 24 years. Should it be there, or should we make some reformulation? What was the intention of Constituent Assembly and the Parliament of India while delineating freedom of speech and expression in context of territorial integrity and defense of India? I will again refer to our interaction with Honorable Justice Mittal, who has just discussed with us that the American doctrine has not been accepted in India, neither by the Constituent Assembly nor by the Supreme Court. Is the US model of freedom of speech and expression applicable in India? Is Kedarnath Singh being rightly used to incorporate the American standard of free speech? In latter cases of Shreya Singhal and Arup Bhuiya is under consideration of the Supreme Court. Last two questions, how and when should the provision of Section 108 of CRPC, one of the most neglected sections. Indeed, 108 of CRPC is a provision which can indeed answer all misuse under section 124A. And there is no doubt that section 124 is being misused, there is no doubt. I'd only say that sometimes it seems to us that the English were in certain sense better than some of us. When they incorporated section 108 in 1898, they incorporated 108 of CRPC has a bouquet of various provisions. 124A is there, 153A is there, 295A is there, and they say that for these cases, these all deal with free speech cases. For these cases, a show cause notice can be given to someone who is suspect, who is intentionally disseminating these type of materials, and take guarantee of their good conduct. So no FIR, first issue show cause notice, take guarantee, and if they resume, they recur, then in that case FIR will be there. This is general understanding, but please see what in 1898 the select committee has said, and we have not followed that. And this will be my concluding remarks. Regarding 108, when it was incorporated in context of sedition, the English said, we are bound to check such obnoxious conduct. But as a rule, the persons who are guilty of it are small and insignificant individuals. They may do enormous mischief among uneducated, foolish and ignorant people, but in themselves they are deserving of very little notice. It is absurd to deal with them by an elaborate state prosecution. We think in most cases, no prosecution at all will be required. Unquote. They themselves said that we need not to prosecute every person. But what is happening these days, that for a drop of a hat, 124 is being registered. What has happened in Bihar, and not only police officers, judicial officers. After NHRC judgment, Arun Jaitley, he was a minister. He wrote a piece in Facebook and he criticized NHRC judgment. And one judicial officer in UP, he has taken suo motu cognizance under 124A. So we cannot just blame police officers. Our judicial officers are sometimes so enthusiastic that they go for registration or taking cognizance of 124A. So if I think that 108 CRPC is taken note of, then probably many misuse under 124A can be checked. So there are many things which we find it very much revealing, very satisfying for us. But this is the theoretical understanding. We have with us Justice Mittal, who has a practical understanding of all those things. So let us wait for his announcement. Thank you very much.
Thank you so much, sir, for your insightful introduction and for this contribution to the legal scholarship. Now, ladies and gentlemen, please join me in welcoming our chief guest, Honorable Justice M.N. Kumar, National Human Rights Commission. Justice Kumar was appointed at Punjab and Haryana High Court in 2001, wherein sir worked as the Executive Chairman of the Legal Services Authority and Chairman of the Mediation Committee. Sir has also had a significant presence in the academic world. Sir has made significant contribution to the Chandigarh Judicial Academy and the Rajiv Gandhi National Law University. Sir has also authored a book, Control of Exclusion Clauses in England and India, published by Ravens, London, way back in 1985. Justice Kumar was also appointed as the Chief Justice of the Jammu and Kashmir High Court in 2012. Justice Kumar was appointed as the Chairman of Company Law Board in 2015 and was the first President of the National Company Law Tribunal in 2016. Sir joined NHRC in 2021. I will invite Sir to please address the gathering.
Esteemed Professor Sinha, Director, Indian Law Institute, Professor Anurag, the primary author of the book which has been released a few minutes ago, Dr. S.C. Purusti, the Registrar, Indian Law Institute, other academicians, scholars, dignitaries of the dais. It is my proud privilege to address such a scholarly gathering, because ordinarily we are in the midst of practical people, lawyers, judges. Very rarely this type of opportunity comes in our way. Friends, you have seen how the birth of a book takes place. Professor Anurag elaborately has told you, we would not have come to know how and what pangs, what pains have gone into producing this 250 pages book. I'm reminded of when I wrote my book, and in 1985 it was published by Ravenwood, Kent, London. And the task was so tedious that I could not dare ever to revise it. So I thought that after I had admitted office as President National Comptroller Tribunal, I will have time. But again, I am caught unaware as a member of National Human Rights Commission. Therefore, whenever you have a call to serve the society and the country, then there is no going back. So book can wait, revision of book can wait, or I will request Professor Sinha to give it to somebody who may undertake the revision of the book. But it is that type of tedious and hard work which goes into producing a book. The end product looks very attractive, but first-hand information which we have got is really enlightening. So, in a way, Professor Anurag has conveyed a message that beware, if you undertake the task of writing something, beware, work hard. You may be stumbling at one place or the other. So better go to 10 places, check yourself, doubt yourself, suspect yourself. Still you may not be perfect. Friends, I was fond of Professor Dicey in a number of ways. But Professor Dicey has said, I will take only one aspect of Professor Dicey in his book, Constitutional Law of England. He says that it may be true that the opinions of the people leads to framing of laws. But it is equally true that law helps people to form opinion. So when the Parliament frames law, it is presumed that it is in accordance with the will of the people. When the law is implemented, then people also start forming opinion about the enactment, about the repercussions of law. Meaning thereby, when the Parliament frames law, Parliament frames law for the whole society, and the weaknesses of the law are exposed when it travels to the implementation stage, when an individual feels the hurt, when an individual feels aggrieved, then he goes to court of law. The judgments which Professor Anurag has collected in his books, whether Garnath, Babulal, other many judgments Professor Anurag has collected, they are the result of individual litigation. And the sedition law has been exposed in its weaknesses when it was examined. I was just going through Sirvai's book on constitutional law. He has given a list of judgments which according to Sirvai are contradictory in terms on the sedition law. And the book is very timely. Article 19(1) of the Constitution gives the right, 91A to be more specific, gives the right of freedom of speech and expression, and it is one of the basic structure of the Constitution. But it is not without any limitation. Under Article 19, Article 2, the reasonable restriction could be imposed. Otherwise, if there are no reasonable restrictions, like in USA, like in England, I would say, when I was student there, Times newspaper published a photograph. It has bust of Lord Canning, but the face of a donkey. Underneath it was written, Canning is an ass. Such is the freedom of speech and expression. And when somebody complained to Lord Canning, you should contempt notice. How can they say that Canning is an ass? Canning said, I treat these things with the contempt it itself. So that is the type of speech, freedom of speech and expression there. So friends, in USA we have not adopted US model. There are reasons why we have not done it. We are not a mature society the way those democracies are. Those societies, like I would take the example of insolvency bankruptcy code. We enacted it in the year 2016, December 2016. They had this law from 1986 in England. So the way the Indian professionals are behaving is far way different than their English counterpart. Naturally, this has to come by passage of time, by there a person with less than 7 years experience is not allowed to touch any corporate insolvency resolution process. Here, resolution professional who have passed an examination conducted by Insolvency Bankruptcy Board of India, he can start dealing with corporate insolvency resolution process in the first very year. With the result, tribunal is flooded with 20, 30, 50 applications. Every case, because they feel very insecure. So the mature democracies like US and UK, we cannot have that type of unrestricted freedom of speech and expression. It has to be, somebody said that if you give unrestricted freedom of speech and expression, then it is like a busy road without traffic lights. It is like a stream without banks. So they will cause more damage. That is why in a society like ours, the restrictions are very, very important, and what is reasonable restrictions have been defined by Supreme Court as early as 1952 in State of Madras versus BG Laws case. Friends, the law of tradition has been one of the most vital and intricate issues at the intersection of constitutional law, criminal law and human rights. Critical scientists and students of law have tried to identify certain common features of sedition but they have miserably failed to find out an acceptable description and a settled structure of sedition, though it is unanimously agreed that sedition has different meanings for different people in different times. It can therefore be said that issues in sedition are intellectually difficult and conceptually confusing. The laws regarding sedition and human rights are extraordinarily complex, and it is a widely misunderstood system of law. While the extending roots of democracy call for abolition of sedition, the possible presence of deleterious, destructive ideologies and emergence of sui generis enemy of terrorism provide grounds for its reflection. The law of sedition in India is not limited to Section 124A of the IPC, Section 95, 108 and 196 of CRPC are directly associated with Section 124A. Section 95 provides for the power to declare certain publications forfeited and to issue search warrants. Section 108 deals with security for good behavior from persons disseminating seditious matters, as Professor Anurag was explaining. And Section 196 prescribes prosecution for offences against the state and for criminal conspiracy to commit such offence for the same. The issue of constitutional validity, as you know, has been examined in the case of Kedarnath versus State of Bihar as back as 1962. I would like to refer what Professor Sinha mentioned, the case of ADM Jabalpur. Now, ADM Jabalpur provides a very strange example in the democratic setup. I remember Narendra, the then Attorney General, answering a query from the bench. The judges asked that if a district magistrate orders the shooting of a person without any reason, crime, could that be justified? Narendra had replied, yes. In emergency, yes. It is the result of, this is reported in the judgment, this is the result of those types of reply on behalf of the state. That amendment was necessity. 369 was added, 369A was added, and the judgment has not been made. And the sole, I think, the center was Justice Khanna, HR Khanna, and he was writing this judgment, sitting in this where his sister lived. And he told his sisters that this is going to cost him CGI-ship of the country. But Khanna was very, very confident. Khanna was committed. He said, nothing doing, come but doing. I have written whatever I felt I am convinced. So with conviction I have written this and I will go ahead. I think the history of constitutional law of our country is remarkable. We have very good judges. I am also reminded of Mr. Justice Mahajan, MC Mahajan. Then MC Mahajan was the Prime Minister of Jammu and Kashmir. He had the brief from Maharaja to go and meet the Prime Minister, Pandit Nehru, and hand over to him the instrument of accession. But Pandit Nehru was not very keen to meet Mr. Mahajan, the Prime Minister of Jammu and Kashmir. and he went to Mr. Patel after 3 days. And Patel arranged a meeting between the Prime Minister and Mr. Mahajan. They met because it was, Mr. Mahajan said that if you don't meet me, I have the order from Maharaja Hari Singh to go to Lahore. Then they met. When they met, the instrument of accession was given. Eventually, Justice Mahajan reached Supreme, and he was to become senior most. That is, one of the senior most. Then he was to become Chief Justice. Prime Minister Nehru toyed with the idea of superseding. Can you believe? At that stage, the whole Supreme Court arose and said, if you supersede, we will all resign. That was the, kindly read the history of our constitutional law and our judiciary. It is remarkable. You will feel proud on our judges, on our judiciary. So friends, the Institute of the ILI is a beacon of light. I came here when Professor Upinder Bakshi was its director. Then I came here when Professor Upinder Bakshi had a argument sort of with Justice Prasad. So Professor Sinha must be aware. So this is an institute of learning. I think there should be compulsory visits of judges to institute like ILI, which I think are going to keep us in good stead. See, in a country like England or US, professors keep the judges on the right track by dissecting their judgment, by telling them that here you have gone wrong. Here you could not have done, you have violated precedent. Supreme Court has said so, High Court has done this, you could not have done it. 5 judges have said so, 3 judges, 2 judges of the Supreme Court could not have done it. Unwarranted, warranted distinction, they all expose. So therefore, your presence in the judicial fora is very, very important. And your dissections of the judgment on day-to-day basis must bring light to those who deviate or mistakenly take a path which is not warranted. I appreciate the efforts of Professor Anurag for bringing out a title of such type, which is, I think, very timely. That the issue is very controversial. It will certainly be a handy guide to the judiciary, to the bar, to the prosecutors, the Office of the Advocate General, the Office of the Attorney General, Solicitor General. All of them can take guidance from this book. I greet Professor Sinha and Professor Anurag for making painstaking effort to bring out this book. Kindly continue contributing your literary books to enrich the wealth of knowledge to all the sections. Your presence is very important to my mind, and with these words, I express my gratitude to Professor Sinha and Professor Anurag for giving me this opportunity to share my views. Thank you so much.
Thank you so much, sir. I will now invite Shri S.C. Prishti, Registrar, Indian Law Institute, to please give a vote of thanks to our honorable guest and our gathering and end today's program.
Thank you, Richard. Honorable Mr. Justice Kumar, Member, National Human Rights Commission, and former Chief Justice, Jammu and Kashmir High Court of India. Professor Manoj Sinha, Director, Indian Law Institute, Professor Anurag, Professor, Indian Law Institute, students of LLM and PhD, and other dignitaries of the dais, audience connected virtually, ladies and gentlemen. A very good evening to all of you. I do formally stand here to place on record my innermost vote of thanks on this auspicious occasion. I have seen a very difficult time during this pandemic, and the coronavirus has drastically affected the academic community to a great extent, as all the academic activities in the institutions of learning from schooling to higher education has been suspended irreparably globally. Out of all of us, those who are having a school-going or college-going children, they know these 2 years what is the loss, which is invisible to all of us. In the current scenario, we must salute the academic fraternity, including our director sir, who has never missed a class online for the students. Along with other corona warriors, we have always praised the doctors, the police, but we have forgot of this strata of the society. Since last 2 years, they are silently doing all this work. Nobody has recognized that one. In KBC, when that school principal came to the dais, that was for the first time we realized that we have missed one strata of the society. As they have disseminated the knowledge to the students in distance mode with a lot of pain. Taking an online class and taking an offline class have a wider difference. For online class, you have to be prepared offline first. The Indian Law Institute is also affected to a great extent because the most enchanting stakeholders, the faculties and the students, are far from us physically. During this time, the institute is organizing this book release function in a blended mode. This evening, we have among ourselves, as already told, Honorable Mr. Justice Vice Mittal sir. He is presently Honorable Member of National Human Rights Commission. He was kind enough to spend some of his very valuable time with us for this occasion, out of his busy schedule. This is really going to boost the morale of our faculty members and motivate them to write numerous academic research publications in future. Along with them, our research scholars too. Thank you very much, sir, on your honesty. As I always said from dais, Professor Manoj Sinha, our very beloved director, is always a source of inner as well as outer motivation and helps us in achieving our desired goals. When we all are disturbed, just go to him. He will show you a road how to be happy. He is the source behind holding such function to bring to the light the academic efforts being done by our faculty members as well as the research scholars and the institute fraternity. Thank you very much, sir, for your continuous positive guidance, motivation and presence here, and also being the main authoritative. From this dais, I wish to inform all again that Professor Dr. Anurag has recently been placed as a professor of the institute. His presence here as the co-author of the book has a great elegance among all of us. He is a very jovial person, as you all know. Thank you, Professor Anurag, for your double achievement and presence on the dais. Like always, there is an invisible part of this program, the support staff. We have a very dedicated team of staff at the back end under the able leadership of our Deputy Registrar, Dr. A.K. Verma, and the whole team. Thanks to the support team for making this event elite and flawless. Again, along with the support staff, very special thanks to our IT team, because during last 2 years we understood what is the role of IT in our life. My sincere thanks to our IT team for spreading this event virtually through Facebook, online, and other modes. Last but not the least, our audience, very heartfelt thanks to all the faculty members who are off the dais, of the offline or online, students of both LLM and PhD, and audience who are connected through virtual mode. Thank you all. Jai Hind.
Just one last announcement from my side. The copies of the book are available, and it's my personal advice. You can ask the authors to sign your copies also today. Please join us for the high tea to my left.